just here to watch my wife. I think she's cheating on me. Or a phrase that was similar to that, I'm paraphrasing that phrase, that a witness by the name of Lisa Weeds told you about when she found someone hiding behind her shed in the middle of the night one day during the summer of 2008. The shed and the fence that directly overlooks 22 Burlington. What does that say about that person? The person who was back there hiding, crossing someone else's front porch, hiding in that 1 to 2 foot space between a shed and a fence that overlooks the back of 22 Burlington Avenue. Especially if you, the jury, using inferences, find that that person was this defendant, who by that point had been out of the Maryland home since April of that year, 2008, who still clearly was seeing 22 Avenue as his home, who was clearly still seeing Alex Danis as his wife, despite what Alex Danis said about him not being in the home or about not wanting to be his wife. Whether that was from misguided love or simple revenge, as I said in my opening to you, this case is about this defendant's inability to accept that that was no longer his home and no longer his wife. And all of the charges and all of the evidence that you've heard during the course of this trial is this defendant's attempt to not accept it. Was this defendant's attempt to get himself noticed, to make his mark with his soon-to-be ex-wife. These charges, the charges that you're going to take back to your jury deliberation room and deliberate about, stem from this defendant's pursuit to annoy, harass, threaten, stalk, and otherwise wave a red flag in front of Alex Danis. And no matter what Alex Danis did, no matter if she replaced her tires, no matter if she called the police, no matter if she obtained a restraining order, subsequently obtained another restraining order, no matter if she got parts of her vehicle fixed, or if she had people that came over specifically to stay with her so that she wasn't home alone at night, no matter what she did, this defendant was going to let her know that he was there and that he could contact her anytime he wanted to, in any way he wanted to, without any consequences. That's where these charges stem from. In going through the evidence that was presented, especially the testimonial evidence that was presented, testimonial evidence is when a witness gets on the stand under oath and provides you facts or provides you evidence. That's what's called testimonial evidence. In going through the testimonial evidence, you may have heard conflicting versions of events. You may have heard one witness say something one way and another witness say something another way, and maybe a third, fourth, and fifth witness say something a different way. Because people are talking about from their perspectives, and it's up to you to decide that conflict. It's up to you to decide what is actually the truth, and what are actually the facts, and which witnesses are credible, which witnesses may not be credible, whether it be from something simple, from maybe they weren't in a position to see what they thought that they saw, or what they told you that they saw, or whether it be from something in terms of motivation or bias towards or against either Alex Danis or this defendant, or whether it be simple lack of memory or not even having the knowledge in the first place. So it's up to you to make a decision as to the credibility of the testimonial evidence that you received, to make a decision if it's something that you can rely on. This is something that you do each and every day. Each and every day you interact with other members of the public that you don't know. Each and every day you go buy a car, you go to Dunkin' Donuts, you go to the bank, you go on a train or a bus, you interact with individuals who tell you things, and you instinctively filter through your mind, is that something that I can rely on? Is that a piece of information that I can use, that I can trust, that I can find to be a fact? And I'm suggesting to you that what you do every day when you do that filtering process, when you do interact with people, is that you're instinctively asking yourselves, how did that person tell that to me? Was the way that that person told that to me realistic? Was the way that that person told that to me, did it have the ring of truth? And you also ask yourselves, why? why would that person be telling me what they're telling me? Is it something that I can rely on because of something that was either for or against my view of why they were telling me? And I would suggest that you also filter through, does what that piece of information that they just gave me make sense in conjunction with other information that I already know to be true? And I'm asking you to take those 3 questions and use them here, again, today, in the jury deliberation. I'm asking yourselves to think of the witness testimony and ask how the witnesses testified, why the witnesses were testifying the way that they did, and did it make sense with the other evidence in the case. In focusing on the how, this is something when you're watching someone and you're looking for little things about how they answer questions or what their demeanor seems or what their responses are that shows you whether or not you can rely on what that person is saying on the stand. You had the opportunity to observe Alex Stamus when she testified. Was there anything about her demeanor? Was there anything about her responses that caused you to question what she was saying? That caused you to say, I believe or disbelieve what she was saying? Was she frank in her answers? Did she only want to answer some of the questions, if not all of the questions? Did she explain to you that there was good times with this defendant in addition to the bad times? And good voicemail messages from this defendant in addition to the bad voicemail messages? And good text messages from this defendant in addition to the bad text messages? Did she explain to you on both direct and cross-examination and redirect examination, I believe, that she did, in fact, at least on one occasion, with her sister and potentially Bob or one of her brothers that were there, try to get the defendant to come out and get the defendant to show himself because she wanted him arrested at that point? Does that make her not credible? Is that the back and forth that the defense attorney mentioned in his opening, that two-way street? Or is that a woman who was fed up with the fact that this defendant, time and time again, she would have something happen to her, or she would get a text message, or she would get a voicemail message, or she would call the police, and nothing would happen? Does that make justification? Does that make her not credible, that she was willing to tell you about her role in that, or does that make her more credible? Does it make her more credible that she did not get on the stand and say she saw this defendant do any of the damage that the defendant is charged with? That she was not the one that pointed the finger at the defendant in the courtroom and said, I saw him do anything? What does that say about her credibility that she didn't come in here and try to tell you that she told you what she could? She told you what she personally saw, heard, said, or did. Defense counsel mentioned Desiree Gordon in his closing argument. Desiree told you that she had a number of charges pending against her related to stealing identities. She told you that she didn't have them pending against her at the time that all this was going on. She told you that she didn't want anything to do with this at the time that all of this was going on. And on one occasion, when she was looking out her window, she saw something happen. And she saw something happen after Alex Stamus went back in the residence. Defense counsel is suggesting that somehow that's inconsistent with what Alex Stamus' testimony is. But Desiree Gordon told you that after Alex Stamus went back in the residence is when she saw this defendant slash Alex Stamus' tires. And it's something that she didn't get up from her couch, walk downstairs, walk out to the police, and offer herself up as a witness at that time. Does that make her less credible? Is that something that would be understandable that she didn't want to get involved at that time? Desiree Gordon did not ask to be a witness in this case. Desiree Gordon lived across the street from a neighbor whose first name she knew to be Alex. Desiree Gordon happened to be home on 2 occasions, specifically on November 17th of 2009, and happened to be coming in and out of her house at several times, and happened to be out on the street when the police went by and came in here and told you what she saw on that night. And when asked, came in here and told you what she saw earlier in that summer. Does that have anything to do with any charges that she may have somehow picked up after this event and actually resolved before she testified in court? Does that have anything to do with anything other than she happened to live across the street from Alex Davis? And what about contrasting witnesses? What about looking at witnesses in terms of how they testified and comparing to other witnesses and how they testified? You saw Judy Gatto testify. You saw Peter Parlow testify. How did they come across in their testimony? Did they come across like they had an agenda? Did they come across like they had certain facts that during the course of their testimony they were going to get out? Those facts were going to get out during the course of their testimony regardless of the questions that were asked. And if you find that that's the way that they testified, then what does that say about how they testified and if you can rely on things that they told you? The second thing that you instinctively ask yourselves about a person when you are determining if you can rely on their statements is why. Why would a person be telling me what they're telling me? Defense counsel has mentioned both in his opening and in his closing something about the fact that there was an ongoing divorce and Ms. Davis's desire not to have to give this defendant any money or any property. Well, what actually did you hear about that during the course of the trial? Well, during the course of the trial, what you have heard is that during almost the entire time that accompanies these charges, so during the March, the June, the July, the August, and the September incidents, there was no divorce proceeding. October of 2008 is when this defendant filed for divorce. So Alex Davis was somehow supposed to be laying this elaborate foundation for some future date that the defendant may have filed for divorce when she was calling the police and reporting things that happened in the 6 months prior to when the divorce was filed. Or maybe what defense counsel meant is that she has some sort of motivation for saying this defendant and was there during the fire. But did Alex Davis get on the stand and say that this defendant was there during the fire? Was it Alex Davis who pointed their finger and described an article of clothing that this defendant was wearing the night of the fire? Or was it, in fact, Doris Ortiz? Or was it, in fact, Desiree Gordon? And what does that say about the motivations that may or may not be behind Alex Davis's testimony, like defense counsel suggested? What possible motivations would other witnesses have in this case? What possible motivations would other people that you heard testify say what they said in terms of evaluate whether or not they would have even been in a position to know or to remember or to be able to give you specific facts? For example, Judy Gatto gave you a particular set of clothing that this defendant was supposed to be wearing on November 17th of 2008. She described it as a particular coat and a particular shirt and a particular pair of pants and was very careful during her testimony to say that every single item of clothing that this defendant owned was light colored. She said it was a camel coat, she said they were light blue jeans, she said it was a light colored hat, and she said it was a light shirt. What possible motivation could she have for saying that? And when asked, well, what was he wearing the day before? She said the same thing, because she said he always wore that outfit. Well, does that mean that she has a specific memory of the fact that he was wearing it the night of the fire? Or does that mean that that was an outfit that he regularly wore, and she's just assuming that he was wearing it on that night? She testified that she knew what his clothing was because she did his laundry. Well, she only did the laundry that he gave her to do, and he had only been living in that house approximately 2 weeks by the time of the fire. So how much of his laundry could she really have known at that time? What about Peter Parlow? Did he seem to have any motivations in what he was saying? Did he seem to have any differences in how he testified for the defense attorney and how he testified for the Commonwealth? And if so, what does that say about whether or not you can rely on his testimony? The third thing to consider in terms of looking at all the evidence is, does it make sense in conjunction with the other evidence in this case? One person's word can be beyond a reasonable doubt if you find those are the facts of the case. But you don't just have Alex Stamis's word, or her facts, or her testimony in this case. You have Alex Stamis's outline that she gave you of the timeline of March, April, May, June, July, August, September, October, and November of 2008. She gave you an outline of things that happened during that time period. But you have other evidence in the case that filled in that outline. Other evidence in the case that colored inside those lines to fill in a complete picture for you. And the other evidence in the case was the other testimonial evidence that you have from the witnesses, as well as all of the physical and documentary evidence that you're going to be able to take back in the jury deliberation room and look at, and listen to, and analyze, and compare. And that evidence, taken as a whole, when you look at it, look at each witness's testimony through the lens of that entire picture, not just what that particular person said on the stand. In looking at Doris Ortiz's testimony, she was able to tell you that she saw this defendant the night of the fire, that it started out over by the truck, on the other side of the truck at that point. She pointed out where he was by the truck. He wasn't between, according to her testimony, the truck and the house, which would be directly next to the porch, where Alex Stamis said that she walked from the upstairs apartment to the downstairs apartment. Doris Ortiz said that at the time that she saw the defendant, he was crouched down on the other side of the car, got up, walked towards her, and she realized who it was. Defense counsel asked a number of questions about whether or not facial hair was present or no facial hair was present, but did Doris Ortiz tell you that the person that she saw, that she identified in court, had a full beard or had a full mustache? Or did she tell you that he had salt and pepper going on his face on that night? And is that consistent with what you heard from Officer Cullen, who saw and interacted with the defendant earlier in that summer, who also described him as having scruff on his face like he hadn't shaved in a couple days, despite the fact that on the form it has to be called clean-shaven because there was no beard and there was no mustache. So the fact that those two things may be consistent, what does that say as to whether or not Doris Ortiz was actually accurately describing the person that she saw that night? And what about Shayna Rosario, who testified that she saw the person in Exhibit 69 down by Alex Stamis's vehicle, that she saw the tires on that car go bad, that she saw the person with the hat walk down there and then come back without a hat. And then a hat was found at the scene, and it was this hat. And she recognized this. What does that say about whether or not she was an advantage point to be able to see what those things? What about Stephen Stamis, who confirmed that earlier Alex Stamis had come to his apartment with blood all over her face and had to use his bathroom to clean it up over something that had just happened upstairs? What about Desiree Gordon, who testified that she also saw this defendant the night of the fire and described what he was wearing? You heard about the clothing that each and every witness described. A black hoodie, a black hat, dark pants. What does that mean in terms of the descriptions and how they matched with each other? And she knew this individual. She knew him by name, and she identified him here in front of you. What about Brian Allen, who was able to give you a timeline of the defendant on November 17th of 2008 for this defendant's whereabouts during the day of the fire? That he left Mr. Allen's residence shortly after 6 o'clock. He'd been there for 2 minutes. That he, meaning Mr. Allen, had actually called the defendant later, about an hour after he left, because the defendant seemed so down, but that he couldn't reach him. And then, in the middle of the night, he received a call from this defendant, and this defendant was asking him if he was mad at him. And the next day, well, later on that morning, because that was in the middle of the night, the defendant, again, came to his place of work. He pointed at the article in the paper and said that he was going to get blamed for that. He asked Mr. Allen for a ride to Air, and Mr. Air and Ms. Giles took him to Air to let him stay with a friend who was living at Air. But then you compare that with Eric Carmine, who said that after the fire, the defendant and he had a conversation, and he told the defendant that the police were looking for him, and the defendant told him said, if the police come to you and are looking for me, tell them I'm in Leominster. What does the fact that he was an heir and he was telling Eric Carmine to tell the police that he was in Leominster say? And Mr. Carmine was able to flesh out the timeline of the 17th of November a little bit more. He talked about how they went on a job, he talked about how they got rid of a car, he talked about how they went to 3 or 4 different bars, he talked about the fact that this defendant was not intoxicated, he talked about how by the time he got back to where he was staying at 7 o'clock, the car that the defendant had been driving was already gone. He talked about the fact that the different things that they did during that day. And what was one thing that was not mentioned in terms of all of the activities that they did that day? One thing that was not mentioned in that litany of activities that day was this defendant going to the temp agency and trying to get a job. So what does that say about whether Judy Gatto had the right day in terms of what she was telling you she saw that night? By her own testimony, every day was the same. There was nothing that stood out about that day. He wore the same thing. He came home at the same time, between 7 and 8 o'clock every night. She gave dinner to her son between 6 and 7 every night. So what does that say as to whether or not Judy Gatto was telling you about the right date in question? But another thing that Mr. Carmine told you was that approximately a couple days before the fire, the defendant had told him that he had gotten indicted. Defense counsel tried to cross him on that and tried to suggest it could have been a couple days after the fire. But you heard Eric Carmine, and you heard Eric Carmine's initial response to that. No, I don't think so. You heard me get up and ask him questions again and ask him, was that shortly before the fire? And you heard him say he thought it was a couple days before the fire. He doesn't know the exact date. But, ladies and gentlemen, that was before the fire. You heard testimony from a number of different police officers. I'm not going to go through every one of their testimony because you heard what they said. But you heard that they confirmed that Alex Davis called the police on a number of occasions between May of 2008 all the way up to when the police were called in November of 2008. You heard that she reported 3 different times that her tires were slashed. She reported damage to her motor vehicle. She reported text messages, and they saw her phone, and they were able to observe text messages beyond even the text messages that you saw. That the damage that they saw to her tires was to the side of the tire, not the tread of the tire, and it looked like it was something that was done with a sharp object, and it was to all 4 tires, and that they were unrepairable at that time. But they also described to you how, on each and every occasion, Alex Davis was visibly upset about what was going on to her. She was visibly alarmed and annoyed, I would suggest, and providing you, and those witnesses were providing you with evidence to Alex Davis's reactions to the pattern of conduct that this defendant was exhibiting over that time period. The only officer's testimony that I'm going to go over is just a couple of them in terms of you not having the photos of the text messages that they described. You heard testimony from an officer, Mike Camara, who went to 22 Burlington Avenue on May 4th of 2008 and saw 4 text messages on Alex Davis's phone. The text messages came in at 10:51 p.m., 10:59 p.m., 11:02 p.m., and 11:08 p.m. And the text messages were monster awoke, poor, death, and later will be worse. Michael Camara also told you that he came back on a different occasion when Shayna Rosario was there and found a hat at the scene. You heard from Officer Rich Levitt, who responded to that same address on July 27th of 2008 and saw 4 text messages. One text message came in on July 20th of 2008 at 11:39 p.m. that said, "Are you truly happy without me?" One text message came in on July 25th of 2008 at 9:30 p.m. that said, "Enjoy, because payback is coming." He saw a text message that came in on July 25th, 2008 at 10:35 p.m. that said, "You won't talk to me, but I'll get your attention." And he saw a text message at 7:25 at 10:52 p.m. that said, "Boom, B-O-O-M, boom." What does that say about the state of mind of this defendant at the time that he was sending those text messages. Days before an M8 device was left on Alex Davis's vehicle. You heard Mike Sylvester say that in addition to the text that he saw that you will have in front of you and that he identified here in court, he also saw the text, quote, what are you giving him? The same text that you heard Bob Mayer say that Alex Davis had received when he was at that house. And he also told you about texts that were coming in documenting the police activity, documenting where they were going, that they were out looking for him. And in fact, in one of them, you see that the defendant sent a text that said, down from the cops. Well, keep in mind that that was shortly before Officer John Cullen on the 9th went to arrest this defendant and he fled. 3 days after the defendant had just been sending texts to Alex Davis documenting the police whereabouts when they were looking for him. You heard from Officer Boulette, completely unrelated to this case, completely unrelated to this police department even, who said that he happened to be sitting in a courtroom on an unrelated case with another unrelated individual and saw something that was disturbing enough to him that it caused him to pay attention to what was going on. That he saw something that seemed so out of place in terms of this defendant turning around and saying something to a woman who was sitting in the front row. And the woman that was sitting in the front row that you heard from other testimony was Alex Davis. And you heard testimony from Officer Blake that he could tell that this defendant was talking to that woman because the way, the direction of his face, and that Alex Davis was the only person that was sitting in that area at all except for a man who was sitting about 6 feet away. But no one else was sitting anywhere near her in the courtroom. You heard testimony from Ms. Giles, Sadie Giles, that she didn't hear anything. You heard testimony from Ms. Gatto thinking that she was the one that the defendant was talking to, but she was sitting on the other side of the courtroom, the other side of that blue line that you saw Officer Boulette write on that diagram. What does that say? Whose testimony do you find the most credible about what was going on in that courtroom based on everything else that you know about this case? Alex Davis was able to give you a frame. The other witnesses and the other testimony are able to fill in the picture. And it's not just witness testimony that you have, it's documents. It's things that you were able to see during the course of the trial. Trooper McCarthy was able to show you an exhibit that he used to demonstrate to you what an M80 or an M-class device looked like. And he showed you photograph E, which is marked for identification, and described for you how that works. That there's a wick at the top, and there's gunpowder inside. And then on the one that he saw, the wick was actually burned down, but that it didn't detonate. And so that it was a live cartridge. And so he had to have it destroyed because it was live. He described for you the damage that that type of explosive could do, and that damage could go in a 360 direction from a device like that. And the only thing that would prevent damage from going in 360 degrees on this particular case was because the windshield was backing one side of it, but the damage would have gone in all of the other directions. And then a live explosive like that needed to be destroyed. You heard from Lieutenant Mike Dillon, the fire investigator in the case, and you have his training experience that he provided to you in Exhibit 171 in terms of the hours and the time and the approximate 66 courses that he's taken in order to do the job that he does in testifying in front of you. And he confirmed that the cause and the origin of the fire was that it was set by an open flame in the trash and recycle bins underneath the corner of Alex Davis's porch, directly below the porch that led to the two main entrances to that home, directly next to the truck where witnesses put the defendant. But he ruled out electrical, he ruled out accidental, and he ruled out cigarette, and that it was a set fire and it was an intentional act. You heard from Judy Gatto, who said that at the time that she was on the porch, what she said that night with the defendant, that the defendant had to use her lighter to light the cigarette. What does that say? And I would suggest that that evidence says to you that shortly before that time period that this defendant was on that porch, he was at a different location. And that location was a 10-minute walk. And I would suggest that the evidence suggests to you that this defendant set that fire. And he had something that set a fire at that stage and didn't have something to set a fire at the time that he got to Ms. Gatto's house. What does that say about possibly where he would have left that? And what does that say to you? You have bank records. You're going to have a large set of bank records. Some of the records were pointed out to you that show that this defendant withdrew the last amount of his money shortly before the day of the fire. You have a number of sets of phone records. You have phone records of Brian Aller. You have phone records of the defendant. You have phone records of Alex Davis. You have 3 different sets of phone records of Alex Davis. The first one being the bills, which are current time and which don't show anything that wasn't paid for. The second 2 sets, one is actual calls back and to, and one is text back and forth. You have the defendant's phone records in terms of from April 1st on, because March wasn't able to be obtained. You heard evidence from Detective Dillon when you look at the defendant's phone records that they're in what's called PDT, not PST, not Pacific Standard Time, but you heard from Detective Dillon that it was PDT, which is 4 hours ahead of what is here in terms of Eastern Standard Time. You saw those records. You've had an occasion to look at them several times when they were put on the stand, and you're going to be able to have them and go back to your jury deliberation room with them and go over them. You saw evidence of text messages. You didn't get to see every single text message yet, but you're going to get to take them back to the jury deliberation room, and you're going to be able to look at them. And you're going to be able to look at exhibit number 12, which states at 12:51 a.m. on that particular day, your doors are unlocked. Exhibit 13, at 5:46 p.m., following use. You're going to see one that's from Exhibit 17. I want you out from a line whore, so don't think there's love for you in me. I paid $6 grand on mortgage, give it back, and I'll sign any divorce papers. Otherwise, suffer forever. Despise all you users. You have Exhibit 18. Feel violated? Question mark. Good. You have Exhibit 20. You know I can't go in a court and using it to scam me out of money. Scammers, scum. You're not going to like what I do. If I can't have a roof over my head because you drained my cash while poor for you for 2 years, then neither will you. A text message that says, in essence, if I can't have a roof over my head, then neither will you. A text message that came in as Exhibit 23, enjoy, because payback is coming. What do all those text messages say about this defendant's state of mind? But you have text messages that were sent to Eleanor Stamos' phone as well. Text messages that were sent to a 202 area code that reflect on Mr. Gordon's phone records. Texts that are sent in terms of got truck plate, see you soon. You saw a number of those text messages in court when the officer was testifying. You have text messages to Philip's phone. Text messages that are called from Jim Gordon's cell. You have a text message on exhibit number 46, 4 down on the left side of the page that says, houses burn nice in window, so dry. What do these things say about this defendant's state of mind? You have voicemail messages. You will have the CD of those voicemail messages back in your jury deliberation. It may have been difficult for you to listen to hear the words on the voice messages when they were played in court, but you'll be able to have that CD. You'll be able to listen to them as many times as you need to determine what is actually being said on those voicemail messages. There are certain voicemail messages that are very significant in terms of the time and the content of those voicemail messages. Voicemail message that was sent on Sunday, May 4th. It's my house, by law. If you don't like it, we'll see you, okay? You want to me? It's time for me with you. You're dead. You have a voicemail message that came on June 1st of 2008. You're my wife. You'll always be my wife. No man will be with you. They'll be scared to be with you. You have voicemail messages that came in the morning that the police attempted to serve the restraining order in uniform, in a March Cruiser, at his work, the same place that they had served him before. Defense counsel suggested that there is a possibility the defendant didn't know the terms of that restraining order. But you heard Detective Kolarski tell you how the defendant was served with the first restraining order, that it was explained to him, that the defendant didn't have any questions about that one. You will hear and you will be able to see the actual restraining orders when you take them back into your jury deliberation room and see that the language is pre-printed on a form. It was previously explained to him in June. The police went and attempted to serve him in a March Cruiser, in uniform, and shortly after they went, the defendant left a voicemail message saying, "You had to send those fucking cops to my work again to get me fired, huh? No more pranks, no cops, no courts, no restraining orders are going to stop me." What does that say about this defendant's actual knowledge of that restraining order, even if he didn't have the piece of paper in his hand? You have all of the records to be able to compare the voicemail messages, the text messages, to the actual records of this defendant and Alex Davis to show the records are coming to and from. All of this evidence gives you a timeline. A timeline not only that was occurring over May, June, July, August, September of 2008, but all of the evidence in this case is giving you a timeline of the events that occurred on November 17th of 2008. A timeline where the evening, the later part of the evening, started at 6 or 6:15 when the defendant left Brian Allard's house at 19 Lamb Street. The defendant had a walk, a short walk, estimated by Detective Dillon of about a 20-minute walk. 20 minutes from 6 to 6:15 would be, at the latest, 6:35. And you have Desiree saying that she saw this defendant after she got home from work, which was 6:30, in and around 22 Burlington Ave. And over the course of the next approximate hour, she saw him more than one time when she went in and out of that home. Then the call for the fire came in at 7:42. Then you heard that at some point he ended up at 92 Weber Street, which is a very short walk, a mile, not even, from, or mile, roughly a mile, from 22 Burlington Street. And would be roughly a 10-minute walk, which would put him at 92 Weber Street shortly before 8 o'clock at night, within the window that Judy said that this defendant regularly came home between 7 and 8 p.m. Nothing out of the ordinary. Nothing that stuck out in her mind. Nothing that would seem unusual for him to come home between 7 and 8 o'clock at night. The burden is on the Commonwealth to show this defendant's guilt beyond a reasonable doubt. That is a burden that the Commonwealth understands, accepts, and that is a burden that has been met in this case. This trial has given you enough evidence to find to a moral certainty that this defendant committed the charges which you are about to deliberate on. Enough evidence to satisfy your reason, satisfy your judgment, and convince your understanding that this defendant is guilty, that these charges are true. And that evidence shows that this defendant intentionally and maliciously engaged in a pattern of conduct directed at Alexander Stanis that seriously alarmed or annoyed her and would cause a reasonable person to suffer substantial emotional distress and placed a threat to her within that time period that placed her in fear of imminent bodily injury or death. You have evidence that he did all those things, that 3 or more acts while the restraining order was in effect, and 3 or more acts when there wasn't a restraining order in effect. You've been provided with this evidence that this defendant intentionally and maliciously damaged Alexander Stanis' vehicle by slashing her tire on 2 occasions. You have evidence that this defendant knowingly violated the restraining order in a number of different ways. He did so on more than one date by texting her. He did so on more than one date by calling her. And he did so on more than one date by violating the 25 yards that he was supposed to stay away. You also heard that he did so on at least 2 occasions by speaking to her in open court. You have evidence that this defendant committed an assault and battery against Alex Davis by punching her in the face. You have evidence that this defendant knowingly and intentionally placed that explosive device on Alex Davis's car. It does not have to be direct evidence. You don't have to have a witness that comes in and says, I saw him place it on the car. You have to be able to have reasonable inferences from the evidence that you were presented, and the judge will be giving you those instructions on what it means to be a reasonable inference and what it means to be circumstantial evidence. And you have that same evidence, that same type of evidence, that this defendant burned Alex Davis's vehicle and caused the fire that burned Alex Davis's home. You have to take people that testify in front of you with all of the things that you can relate to and all of the things that you can't. You have to take them as they are. It does not matter that you might have done something differently. It does not matter that you might have said something differently or done something different than how Alex Davis did. What matters is that all witnesses, Alex Davis, every other witness that testified in front of you, are there to serve a purpose. They're there to put evidence and put facts in your jury box. They're there to give you things to take back to your room, to be able to put together and form a complete picture of everything that this defendant did. And everything that this defendant did are the charges that you will be deliberating on. And the combination of all of that evidence has proved beyond a reasonable doubt that this defendant is guilty of these charges. And therefore, at this time, I'm asking you to say that these charges are true. I'm asking you to say that this defendant is guilty and no more. Thank you.